No, you won't.
Welcome to the third in a series of mock divorce mediations. Today we have Gary Borger being the mediator, Jeff Urbach and Cindy Wilson being the couple. As usual, Gary, as the mediator, has not seen the fact pattern to make the role play as close to real life as possible. The role play will go on for about 20 to 30 minutes. At the end, you'll be able to ask questions by raising your hand. During the role play, I do not look at chats because I'm concentrating on the players. Now to the introductions. Cindy Wilson, founder of the Wilson Family Law, LLC, is experienced in all phases of litigation concerning divorce, custody, alimony, and child support and equitable distribution, and domestic violence. She is a member of the New Jersey Court Roster of Family Mediators, the New Jersey Association of Professional Mediators, and volunteers her time as an intensive settlement panelist for the courts. Jeffrey Urbach has over 40 years of experience in financial forensics, divorce taxation, business valuation, and general accounting. Jeff has been qualified in New Jersey courts as an expert witness in financial forensics and business valuation. He's on the NJ Judicial Roster of Mediators for economic aspects of family law. He's also trained in collaborative law. Gary Borger has engaged in the practice of law for the last 43 years in Cherry Hill, New Jersey. His practice concentrates on negotiation, mediation, litigation of family law disputes. His practice involves the myriad legal problems associated with separation and divorce and associated tort claims, and includes drafting and negotiation of cohabitation, premarital and marital settlement agreements. So with that, we now join our couple in mediation.
Gary's
Gary,
muted.
you're
muted.
You're on mute.
It's good to have you back. It was good to meet you both at our first meeting, get to know one another, and get an idea of what's involved in your family. You've done your homework, I assume?
Mhm.
Yes.
Yeah.
So today, we're going to open up by, I always like to ask the couple, is there anything emergent or urgent that you need to discuss at the outset of today's mediation?
Nothing right now.
Nothing urgent.
How about you, George? No? Okay.
I'm just anxious to get this done with, and we have a lot of issues that we need to resolve, and we're hoping you can, help us through it.
Now, what's foremost on your mind at this point?
Cindy, I'm Lisa, rather. Lisa.
Yeah, Lisa.
I
Cindy's your girlfriend, right?
Yeah. I think it is probably because of the way he's treated me and what he's done in our marriage, but I won't bring that up. So I'm the one who has always been the provider in this family. And I've been reading that he's supposed to be getting like 50% of all of the assets. And I don't think that's fair. I've been the one who's working harder through all of this. And so the fact that it's going to be 50-50, we really need to discuss that.
Well, before George responds, Lisa, let me remind you that being in mediation, the law doesn't apply the way it would in a courtroom. And I can't give legal advice, but you have both consulted with independent attorneys, I assume. Is that right?
Yeah, and my lawyer told me that this marriage is like a partnership, and so Lisa was definitely the higher earner, but I did my share in the house, and took care of things on my end. So this was our partnership.
And you acknowledge that, don't you, Cindy, that you had a partnership together as husband and wife and parents?
Perhaps, but I think monetarily.
What do you mean, perhaps?
Let me finish, please. I think monetarily, I've definitely provided more, and I've always asked George to save more and to be aware of what our finances were. And he wasn't. He just worked. He didn't work hard at all, and he would just come home. That's one of the reasons we're getting married. I'm the one who always goes out and busts my hump, and he hasn't. So for him to just walk out of this marriage with most of the money that I earned doesn't seem fair and equitable. And I thought this was supposed to be fair and equitable, George.
Well, one of the advantages, and thank you for not jumping in right away, George. Because we remember, as I told you, listen to what the other person is saying, as George appears to have done, Lisa, and absorb it, try to understand where the other person is coming from, not just your response to what you just heard. And I applaud you for doing that, Jeff. And Lisa, you've done a good job of that in our first meeting. And you will here too. I trust you both. In mediation, we're really freed from the constraints of the courtroom, where a judge is compelled to apply the law however that judge interprets it. And that varies widely from courtroom to courtroom, and even from case to case with one judge. So you are the judges here. You get to decide what you think is fair on your own barometer of fairness. So whether generally 50-50 is the rule or isn't, doesn't really matter. It's what the two of you come away with that you feel is fair. Now, you've both been employed throughout much of the marriage, is that right?
Yep.
Yes.
And while Cindy, you have gone through the corporate route, George has worked for in government and amassed a pension and had a steady income there. Is that right?
Yeah, I have to tell you, you asked if there were any emergent issues or whatever. I'm really concerned about the house because I bought that house before we got married with my own money, and Lisa's talking about not wanting to share things, but I don't hear her saying, I'm acknowledging that maybe you've got some extra equity in the house or something. The last I heard, she just wants to split that too. So, where are we going with this? It's got to be even-handed.
Shall we talk about the house?
Sure.
Yeah, it's like my hot button issue right now.
Okay, well, let's talk about it, because there's nothing worse than having the elephant in the room and nobody acknowledging it. Lisa, what are your thoughts about the house?
I understand that he put together the down payment. It feels like sometimes when we talk about it, he doesn't want to acknowledge that throughout the marriage, though, I've contributed a lot to it also. So I'm willing to acknowledge that there's something there for him, but then there's got to be some sort of recognition that I've made most of the money throughout the marriage, and that means I've paid most toward the house.
Can I say something?
Yes.
So, Lisa makes it out like, she's been this hard worker, and yes, she is a hard worker. But there was also a period, Lisa, where you were unemployed. And if you remember, I went through my family's inheritance, as small as it was, to pay our bills while you were out there looking for a new job. So, don't make it sound like, I've done nothing here in this relationship. I just don't think I don't think it's accurate. I don't think it's fair.
Do you acknowledge that, Lisa, that George's, as I recall from my notes, $50,000 inheritance was used to pay the bills while you were out of work?
Yes, that's true.
And I assume you've talked to your attorneys about inheritances and gifts and things like that, right? Yeah. And as we discussed, I really don't want either one of you to bring up what your attorney told you. That's private and sacrosanct, just like this mediation is confidential. So it's never good to get into an argument about my attorney said, oh yeah, well, my attorney said. But if you've discussed all that, and it sounds to me like each of you, and tell me if I'm wrong, each of you acknowledges that the other has made a substantial contribution to your marital partnership. Isn't that true?
Yeah, I mean, that's the way I look at it, and that's why I just bristle when I keep hearing her talk about not only that she doesn't want to share things 50-50, but we mentioned when we last saw you that she got a bonus and she doesn't want to put that into the pot. She says that's hers. And I'll be honest with you, this is ticking me off.
Well, one of the ways I like to look at mediation is like a jigsaw puzzle. We put all the pieces on the table in front of all of us. The three of us are looking at the pieces together. Nobody hides any or keeps any pieces in your pocket, but they're all fully disclosed. And now we have to put those pieces together in a way that makes a picture that's acceptable to both of you. May not be perfect, may not be beautiful, but at least it's a picture that allows you to get on with your life. So each of these pieces is important. The house is one. The bonus that Lisa earned and is about to receive. So let's talk about the house first. Understanding the bonus is another topic we have to go over as well. What about the house? The options, as we discussed, is it can be sold. There can be a buyout. Thank goodness you're both financially sound and you're not going to lose your house like some couples. So what are your thoughts about what's going to happen with the house?
Well, I think that George wants the house because he bought it and he put it together. And because of that, I think I'd be willing to allow him to stay in the house as long as he continues to maintain it for the kids. But then if I'm going to acknowledge that, then I'm going to need that $45,000 bonus to put towards something where I'm going to have to live. It's not just a matter of not wanting him to have it, but I need that money.
Let me see if I understand what you're saying, Lisa, that the house, George would remain in the house, you would move out. Is that right?
I'm offering that, yeah.
Okay, as a possible proposal, because we're brainstorming here.
Right.
Not committing to anything right now. When would the house become George's, or would it be sold under your proposal?
I guess I'd leave that up to George.
And George, what are your thoughts of what should happen with the house?
Well, I have a lot of sentimental connection with the house. I would like to keep it. I have to consult. I understand that once Lisa moves out, she'll be off the mortgage, and I think I'll be able to refinance the mortgage and just have it be on it myself. But I haven't yet confirmed that. You gave us the name of a mortgage broker, and I just haven't had a chance to follow up on that.
Okay. And it appears to me from what you told me at our initial meeting that the house is worth about $360,000. Is that right?
Yeah, plus or minus. Yep.
And there's about 300,000 left on the, I'm sorry, 560 with about 300,000 left on the mortgage. I'm sorry.
Yeah.
So that leaves about $260,000 of equity to discuss being divided up in some way. And as we discussed in the first meeting, one asset can offset another. Some people come in and think that everything has to be sold and divided 50-50, and that's just not the case. We start with a blank slate and you decide what works for you. So let's assume that George, under this scenario we're discussing as one possibility, would keep the house, and therefore he gets $260,000 on his side of the balance sheet, if you will. Now, should that be an equal division, Lisa, what are your thoughts about that? With George having acquired it 3 years prior to the marriage with money put down, about $40,000, I believe, that he saved prior to buying the home.
Well, I'd be willing to offset that so that he doesn't have to get a larger mortgage, because on his income, I don't know that he would qualify entirely. But then he'd have to waive his rights in my bonus, and then also in my stock options.
Well, can we talk about one thing at a time? I'd be willing to trade, quote unquote, that 40 that, I put down before we got married, if you're willing to put that 45 bonus into the marital pot and just call it even on that.
So you would forego your $40,000 claim for the.
I would just to get this thing moving along, but I also want you to throw in your 45, that bonus into the marital pot.
Okay, I'd be willing to do that, but I still need the options. So you're going to mortgage the house or refinance the house and give me my $130,000 in equity?
Yeah, assuming that I can qualify. If I can't qualify, then we'll have no choice unless you want to take over the home and, we just flip it around. But assuming I can qualify, yeah. But now, I'm sorry, go ahead.
I was just going to ask, are there different ways that we can move the assets around instead of making George refinance for $260,000 plus?
Well, if there's a $260,000 mortgage loan that's outstanding at this point, and you're both on that mortgage now, as I understand it, I guess it was through refinancing, then interest rates are low now. The options would be George would refinance the $260,000 mortgage at today's interest rates in his name alone if he qualifies, and he should be able to find that out by our next meeting by talking to the mortgage broker that he agreed to use. Then you would have $130,000, as you describe it, Lisa, on your side of the balance sheet that you would have to get from other assets that George otherwise would be entitled to. Does that make
Gary, can you make sure there's a time frame that he has to do the mortgage broker? Because that's been the whole issue of our marriage. He says he's going to do something and then he doesn't. So I'm going to be sitting here waiting on my money.
Well, let's ask George, how long do you think you'll need to get the information the broker needs to see if you qualify?
The mortgage broker told me it would take, once I get him all the information that he needs, tax returns and all the rest of that, 3 to 4 weeks, maybe sooner, maybe even, to get an answer, to get a verbal on it. But, before we do that, I don't know all the assets. As you know, one of the issues that came up the last time is Lisa has refused to disclose information about the stock options. And that's another asset that, is on the table. And I know nothing about it. And she's refused to share any information.
Yeah, if you'll indulge me, let me come back to that in a minute, okay?
Sure.
Just set that aside for the moment. In terms of the home, how quickly do you think you can get the paperwork to the mortgage broker?
I don't know, about 10 days or so, plus or minus. I should be able to do that.
So Lisa, if George commits to get that to the broker within 10 days, then it means about a month roughly, according to what he said, for us to have an answer. Does that work for you?
Yes. Thank you, Gary.
Okay, good. So it sounds like the two of you are moving along that option well, and we'll see where it plays out. And if it works, great. If not, we'll drop back 10 yards and reconsider other options. There's a lot of brainstorming that goes on in mediation, and that's wonderful. We have 3 bright people here, and that's one of the advantages of mediation. Now, the stock options. Lisa, I talked about the analogy to a jigsaw puzzle. If there are pieces that someone has not put on the table, we're not going to have a complete picture when we're done, right?
Right.
So one of the touchstones or cornerstones, if you will, of mediation is transparency and complete disclosure. It's very important. Remember we talked about that at our first meeting? It's very important that each of you reveals everything financial that needs to be revealed so that you each can feel a level of confidence in one another and in any agreement that you reach. So let's talk about those stock options, Lisa. Let me have your thoughts on that.
Well, they're vested and they're worth about $30,000. But again, it's like I'm bringing everything to the table and he's not bringing anything to the table.
Why do you feel that?
Because we still don't have information on his pension. I know it's going to be valued at somewhere probably around 200,000, but is he going to keep that? Does that mean he gets to keep his pension? I don't get any of that.
Well, I think the important thing is to not get ahead of ourselves and make sure we have everything on the table first before we start talking about how to divide it up. The house was a little easier because you both came to me and said last time you think it's worth about 560 and there's 300,000 roughly left on the mortgage. So that's pretty easy. George, you're going to have to bring us in whatever documentation you have about the pension. Will you do that?
Yeah. Now, what I understand, I know you don't want us to talk about our conversations with our attorney, but this is no big deal. He did say that there are certain firms out there that value these pensions, and I get it. I have to have it valued. Can you make some recommendations, and I will follow up and get them the paperwork?
Sure, but you don't have to have it valued necessarily. We have options in mediation. One is to have it valued and look at it as what I call a economically comparable fund that would provide for the monthly payments that the state has committed to pay you once you retire and reach retirement age. So we can treat this in one of two ways. One is we look at it as a future flow of income, the pension, as we normally think of pensions. And you agree in some formulaic way to divide it up when you retire, George. A second option is to have one of these appraisal people give us a calculation of the equivalent lump sum fund of money that basically, if you paid, would guarantee you the same monthly payment that the state has committed to pay you upon retirement, whether it's 200,000, 150,000, whatever the number is. And then we can compare that to other assets like Lisa's 401k, her stock options, and her stock in the company.
So I'm really confused. Are you saying that I can just pay her, 30 years or whenever from now when I retire, some part of my monthly check from New Jersey? Or
How will I know when he retires?
I'm very confused.
Well, you could. That's an option. Cindy, what were you saying?
How will I know when he retires? Suppose he retires and doesn't pay me.
Well, if you two agree that you're going to get a percentage share of the marital portion of the pension, whatever was acquired during the marriage, if you agree to that, there'll be a court order entered as part of your divorce, which will happen after you reach an agreement. And that court order will be served on the state of New Jersey. And the state will then have a notation under Jeff's pension, George, I keep calling you Jeff, under George's pension entitlement. And so when he retires, automatically a check will be cut to you every month, and a larger check will be cut to him because he'll continue to work there after the marriage is over. So that is an option, and there is protection there. We don't have to decide today, but those are two approaches.
It sounds awfully complicated.
Not so much. I mean, it's done all the time. And we have independent people draft those orders, which is probably in the range of $500, which is not a lot of money for an asset that big. And they draft the language that makes it qualify so that it's not taxed to George when he retires in its entirety, but rather the portion you get, Lisa, is taxed to you, and the portion that George gets is taxed to him. That's one option. And the other is to compare it or have someone calculate a fund and then just put it on the list as another asset that has a monetary value to it, fixed as of today.
So if I have those special stocks, that ESOP, and it's valued at 38,000, can we offset the pension on that amount?
That's one of the things we can do. We could, for example, in George's column, have the lump sum equivalent present value of his pension
Mhm.
and his Roth IRA. And then on your side of the column, we could have your stock options, what they're worth today, if they were exercised today, and your ESOP company stock, all in your column, along with your Roth IRA and your 401k. And then we start adding up numbers. And then you'll tell me at some point, what do we do with those numbers? They don't
Can
have to
I,
be equal. It's
you
what the
know,
two of you feels is fair.
Gary, I spoke to one of my buddies who's a sort of like a financial person. And he said that these stock options go up and down in value every day. So he said, in 5 years, it might be worth 40 or 50 or 60,000. And so I'm not sure that, I'm ready to commit to this $30,000 number. I don't even understand where it came from. How did we get it?
It's complicated, isn't it?
Yeah.
Yeah. Well, one of the ways to deal with, again, you have options, just like with the house. You can have a buyout, somebody keeps it, buys out the other person, or you can sell it. With the stock options, we can look at what they're worth today. One option is to look at it and compare the strike price, what you could receive if you exercise those options today, what that would be after taxes. Or you could agree that Lisa would hold those stock options into the future until you, George, decide with your financial advisor, based on the rising price of her company stock, that you want to exercise them at that point, at which point, then Lisa could exercise the stock option, get a fund of money. She's going to pay taxes on it. And then that will be your share of a buyout at that time. So those are two options as well. I know it's complicated and it's not a simple black and white 50-50, I get half of everything, but you are going to work it through and massage it just like it's a piece of clay and form it into what works for the two of you.
So I really have to think about it because, well, Lisa, are you willing to commit to a $30,000 value? I mean, it could go down in value,
Well, George, you know that that's a hot button for me, just like the house is for you. You worked hard for that house. I know what you pulled together, but you once acknowledged that me working hard, that's how I got those stock options. And they have special value to me more than just the dollar value. So you should just please let me keep those stock options and you balance it off with something else.
Is that something, George, that sounds like a possibility to discuss?
I'm not sure what keeping them and balancing them off means. Are we saying that you'll put a number of 30 on it, let's say, and I'll get, let's say, another 30 out of the house when we refinance? Lisa, is that what you're saying?
Balancing it that way, yes.
Balancing
and
it
that would
that
allow
way.
you to refinance less money to buy me out of the house.
I can live with that.
Yeah,
I can live with that.
Good. So this is the kind of progress we're looking for. You are coming up with your own form of fairness of what works for you. And that's what we try to do in mediation. So I'd like you, Lisa, to give us the details on the stock options. Will you do that?
I will.
And then we're going to share, the three of us share everything. So George, at that point, you can have your financial advisor and your attorney, if you want, look at them behind the scenes and get a better sense of what they are. And that's why we have financial advisors and lawyers to help us understand the things that aren't within our area of expertise. So we've talked about, the recap a little bit, we've talked about options on the house, a possible buyout. George is going to move ahead within 10 days and get the paperwork to his mortgage broker, who then will need about 3 to 4 weeks to see if George qualifies for a mortgage to pay off the existing joint mortgage. And Lisa's going to get the stock option documents for George to be able to look at. And George, you're going to get the pension information from the state. And that way we're starting to get all the pieces put together on the table. And then we can pursue some of the options you talked about today, such as George buying Lisa out of the house with a refinancing of the mortgage to get her name off the mortgage loan. Lisa keeping the stock options that are important to her. And George having to pay Lisa less from the equity in the home. Does that sound like a fair summary of what we discussed?
Yeah.
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 Do you have any questions about any of those at this point?
Does that mean we're agreed upon that this is it?
No, this was just one option or a series of options that we're discussing.
Yeah,
So
I
we're
still want to
starting-
go. Yeah, I still want to get feedback from my lawyer and my financial advisor, but
Absolutely, you both should. But I think if you have an idea of where the other person is coming from, as you've developed today, you can then take those ideas back to your experts, your lawyer, your financial advisor, each of you, discuss them, pros and cons, mold them over in your head. And so that when we meet next time, you'll have a pretty good idea of whether that seems to work. So you don't have an agreement today. You just have an idea of something that will be acceptable to both of you with regard to the house, the stock options, and the employee stock ownership plan stock. Okay?
I'm not sure we actually dealt with that last item there. What's it
ESOP,
called?
the
An
stock?
ESOP or something?
Right. Yeah.
Is that so? Is that going to be something that we're going to share? Is that we're going to, when we add up, like you said, all these assets and stuff?
Well, you're talking about sharing them in a sense of
The dollar amount.
What's that, George?
The dollar value. I'm sorry.
Yes. That would be in Lisa's column. And therefore, when you look at how much you owe her on the home, the equity in the home, it'll reduce what you owe her. Right?
Okay. I wasn't really clear on that. I just wanted to make sure that Lisa wasn't trying to pull a fast one on me there.
George, you're going to get your fair share. Just excited.
Yeah.
No, I think you've both been very good today at expressing what's important to you, what you would like to see by way of an outcome, what assets each of you would like to keep. And you've begun to discuss a way to share those assets without having to divide each one up one by one, which doesn't really seem to meet the needs each of you have or the desires each of you has to move ahead and start fresh, knowing exactly what you have in the bank, so to speak, and what your obligations are to one another. This might be a good point for us to take a break. What do you think?
Yeah, I'm really beat. You're
All right.
tough, Lisa.
Thanks, George.
Okay. So can you see me? Is my video on?
Yours,
Yes.
yeah, it is.
Okay, I'm not seeing. I hid my self view.
You're handsome as ever.
Right. Okay. Let me start with you, Gary. Gary, how do you think that went?
I think it went well. It evolved nicely from some hostility, some suspicion, some lack of trust into a sense of willingness to disclose, willingness to be open. Lisa, if you will, picked up on that and understood she has to bring the papers forth. They were good at discussing what was important to each of them, and they seemed to develop a sense of trust, build on their sense of trust as it went on.
Okay, Cindy, from your perspective, as a one of the parties.
I thought Gary did a great job of not letting us get derailed. In other words, circling right back to, well, let's just stay focused on the house for a few minutes. Let's try to see how far we can get with that. And then no matter, what Jeff or I brought to him, he tried to resolve one thing at a time. And then was also very explanatory in the way he was approaching it.
Okay,
Just helpful.
Jeff?
Yeah, I everything that Cindy said. Plus, I think Gary did a good job in keeping us from, going down the rabbit hole on each of these issues, which we could easily have done. He sort of, pulled us back to take a bigger picture view of the thing, which I thought was very good, very helpful.
Okay. You know, I have never done an online mediation since I retired before all of this happened. But when I did in-person mediations, I always used a flip chart. And I found the flip chart invaluable to keep people focused and me focused on what the heck was going on with respect to financial matters. Have any of you found a good way to do that with online matters? Because it's really hard keeping the various parts in your mind. So I throw that question out to you.
I haven't done, go ahead, Cindy.
Oh, I was just going to say, I've been using more Microsoft Excel spreadsheets and using share screen, and which has been a blessing and a curse, because in many ways I do it, quickly with them, with everybody on the screen. But then at the same time, sometimes we're moving so fast, I like to fill in formulas in that. And I just afterwards make sure I check my math and make sure that the cells read the right way. But it does help to put the numbers up, so everybody, instead of necessarily focusing on everybody on the Brady Bunch screen, having the parties focus on the spreadsheet, and the numbers sometimes brings down the tenor of the mediation.
Yeah, what we have to remember is that we each learn and process differently. Some of us are verbal learners, some are visual learners, some are tactile learners. We can't do much about tactile, but you can, by using a chart of some sort, like we used to do in person with a whiteboard in our conference room, let people to see if those who are visual learners can then process the numbers as they see them in front of them, whereas other people are good with hearing and processing. So it's harder to do, Carl, online.
Yeah, I would think
I think, and I was just going to add, particularly if we're using breakout rooms, it starts to get complicated, because you're kind of flipping back and forth between the breakout rooms, and then you need to bring the parties all together into that central room, if you will, and then share the screen. So unless you're one of these people that are using Zoom every day and are incredibly adept at it, it can get out of control very quickly.
Right. At the beginning, Gary, you said, I guess Cindy had talked about, 50%, and if he's entitled to 50%, I don't think that's right. And you said, well, I can't give you legal advice. Now, I think actually, since you're a lawyer, you could give legal advice. I assume you don't want to, but wouldn't you at that point have wanted to say, well, this is an equitable distribution state, so you can decide whatever you want? Well,
I have two responses. One is, I don't think I can give legal advice to two people who have opposing interests. I think that would be unethical. So I don't think I can, not just that I don't want to. Number two.
I'll send you a memo on that.
Okay.
You can.
Yeah, thank you, Carl. I'm always happy to be challenged.
Okay.
Because nobody knows it all. And secondly, I don't like to use legal terms in mediation more than I have to. So I'd rather talk about what you two think is fair rather than say it's equitable or equitable distribution. I might say, in front of a judge may decide a certain way in the way he or she interprets the law, and maybe it'll be 50-50 in the courtroom. I don't know. Nobody knows until after the trial is over, and we're not going there. But what you have to do is create your own law, the law of George and Lisa, that applies to you and whatever's fair to the two of you. So I try to keep away from legalese as much as I can.
Okay. And another point you said, I don't want you to tell me what your attorney said.
Right.
I would always ask. And most of the time, they would tell me. And
Yeah,
I
but-
found that very helpful because a lot of times they were right on the same place. So I
But
was
what-
wondering why you don't ask.
What if they disagree? I don't ask because I've seen it get into, I hate to use the term, but a pissing match where one
Mhm.
says, well, my lawyer said, and the other one says, oh no, my lawyer said that's not going to happen. And you can't resolve that in mediation.
Okay.
So that's the reason I
Mhm.
try to avoid it. Plus, and that's the main reason, but also I want to keep that attorney-client relationship sacrosanct, as I said. It's out there, it's private, don't bring it in here. Attorneys give you knowledge, you stuff into your head, and you carry it with you into mediation, but it's not part of what we discuss.
Okay. So Felicia has a question. Felicia, unmute yourself and put your
Hi,
video.
Felicia.
Felicia?
I think she fell asleep.
Okay, we'll go along to Jay.
Actually, no, I
There
just
she
want to
is.
say I didn't have a question. I don't know why my name came up, but I do want to say I love the jigsaw puzzle analogy. That was wonderful.
Thank you.
Okay.
But I didn't have a question, so I don't know why it said I did, but
Because it says you raised your hand.
I did not.
Okay. Jay has a question.
Like Dr. Strangelove.
You're dating us.
All right. All right. Hi. It was it's quite interesting, but I do have a question to Gary. Did you consider meeting with each of the participants separately before you got together as a group for the purpose of letting each one focus on his or her assets to arrive at valuations, so in anticipation of the group meeting, so that you've already had the preliminaries, you know what each one has in terms of an individual estate, and then you could start discussing them more in depth. Perhaps you may have already short-circuited the 4 weeks that that Jeff would have needed, or George, I'm sorry, would have needed for getting the value on the mortgage, and perhaps Cindy would have been able to have gotten something more tangible in terms of the 401k and the option plans that are available, and you would have had that at this meeting, so you could really have gotten into something more in depth.
Well, Jay, this is interesting. This is how we all differ. I was trained initially in mediation by Carl Vinier back in, I don't know, sometime in the 80s, I think, or 81 or something. And the one thing Carl emphasized, which always stuck with me, was that mediation is a three-legged table, and you can't take one of the legs out. And so I think you have to build a sense of trust among the three of you, each with the others, and also the sense of openness and transparency that everything occurs in this meeting. I avoid not canvassing. What's the word I want?
The one-on-one?
Caucusing.
Caucusing. I'm sorry. Yes. I avoid caucusing in family mediations as much as I can because of the sense of mistrust that's can be built up, that what did she really say to him? What did she tell him about me? What did he say? So I try to avoid that in family mediations, Jay. I think if it's commercial or mediation of a tort claim, it might be very different. Civil litigation that goes into mediation. But in family, I really try to avoid that and have it brought out in the open with the three of us meeting together at all times, nothing being done behind the scenes, so to speak. Does that help explain the way I approach
Well,
it?
yeah, I just thought that since you have these, well, there are two things that come to my mind. There might be assets that may not be brought out in a joint session, as opposed to sitting with each one individually and going through, if you will, the different categories of assets you might have. And for example, insurance. People may not think of insurance as investments, but they are. And something like that, when you talk about investments, you say, oh, by the way, you have the insurance. Is there any value in those policies? And what I'm saying is, you allow them to go out and find that information before you get together, so as to, when you do get together, you're really using that time in the valuable essence of this discussing the different assets and what their values are, and as you discussed, the balance sheet and what can go on one side of the balance sheet versus the other's balance sheet, and things like that. I just thought it's a way of perhaps not saving time, but making better use of time.
Cindy, let me ask you a question. Do you how much do you caucus, or is it mostly in joint session?
Mostly in joint sessions. And to answer Jay's question there, I find that exploring all the assets is very valuable for both, because it's been my experience that both spouses don't always know, fully appreciate, or understand what each asset is or how it's been valued. So for me, one of the very first steps in mediation is the data gathering step, is making sure that it all comes to the table, and that not only do you have statements, but that you have full understanding. Usually there's one party that may not be as financially sophisticated as the other. So just like Jay said about life insurance, that person may not know the difference between term and whole life. And if it is whole life, how or whether it can actually be divided. And all of those aspects in a discussion forum lets that less sophisticated party become more educated and aware in a non-threatening way. So it's me asking all the questions about the asset while the other person listens and hears.
So Gary, I'm sorry, go ahead, Jeff.
I was just going to say, as being a financial and a numbers person, I like to have, if I can, either a real case information statement, or if they haven't filed yet, an ersatz, if you will, case information statement, as best they can. So, I asked them to put it together, and then I'll walk them through it, and very much like Cindy was saying, there's oftentimes an imbalance, or one is more sophisticated than the other. But being a financial and a numbers person, I'm very comfortable with taking that and starting with it, and then raising questions from my end and explaining to the other parties.
So this was an equitable distribution role play. When would you have sent out to the parties, you, Gary, as the mediator, your request for a balance sheet, or a balance sheet, essentially?
Yeah, what I do is, when I confirm the initial mediation session, I send a set of questions or an outline I've put together, asking the parties to list real estate, retirement accounts, investment accounts, savings, vehicles, it's life insurance, so that at least I have a husband's list and a wife's list. I can compare them to see if they match and they all agree. And I tell them in that letter, it's okay for them to sit down and answer these, to fill this in collectively, jointly, so that when we meet at the first session, I have it in front of me to be able to see the bare bones skeleton of the marital estate.
Okay. And Cindy, what do you do, and when do you do it?
So during our first session, during the consultation, when I do a mediation consultation, towards the end, I ask them to begin to gather all those documents so that they can bring it all to the first session. And then during the first session, we'll walk through, I will walk through all the factual information about children and any special needs, all of the information, historical incomes, and then the assets. And sometimes they'll bring everything, sometimes they won't, and lay the foundation for it. My first mediation session, I try, unless there's really good momentum, to keep it to like 2 hours at the most. And then the third, sometimes that will exceed that. And then, so gathering getting them to understand the data they need, why they need that, to start to think about, like with the house, for instance, start thinking about how you want to divide the house up. What does it mean to be refinanced? Because I find often they come and there's really not much of an understanding of how the divorce process is going to work. So I try to educate them with that first, get the data started. But I also try to be very mindful of keeping the sessions to an absolute minimum, to the possible, as much as possible, because it is a lot of money that they're spending on us.
I would only add that, yeah, in my experience, the balance sheet in terms of finances is, at least in my experience, the easier part of it, as opposed to the living expenses. I find, the marital lifestyle, if you will, is oftentimes much more contentious than the pretty much black and white things of, yeah, this is what we own, this is what we owe kind of thing.
Right. Anju's had her hand up for quite a while, so I'm going to let her talk. Anju, unmute yourself, please.
Hey, Carl. Good morning.
Hey, Anju. Yep.
That's
Hi,
good job,
Anju.
Gary. So, Gary, I in actuality, would you have gone through a list of assets before you started talking about the disposition of them?
Yes, I guess you could assume that in this session, it follows the initial session where people listed the assets. We talked about them, but we didn't go beyond that. We sort of did an inventory at the first session. And this one was now a discussion of what are your thoughts about how to deal with each of these assets? Yes. Yeah, you certainly have to do that. You need that inventory.
Okay, so they at that point would be looking at a list with a summary of how much the dollar amount is.
Yes.
Right? Because at any point you can point out whatever is in dispute is a minor percentage of the total.
Right.
Okay, I just wanted, because without the visual, it's very hard to follow a lot of the equitable distribution that you were talking about. You don't have perspective. That's why I'm asking. This is the same role play we do in the 40-hour class, so it's nice to see it. And I think the people who took the class would appreciate it.
And I think that's what Carl was alluding to. How do you visually have something in front of you in a virtual mediation where everybody can follow along? And it can be done by screen sharing, as Cindy alluded to, in her case with an Excel spreadsheet. I've not found a way yet, maybe somebody can come up with this, of having an Etch-a-Sketch, so to speak, where you can, on an iPad or something, keep things going and let everybody share and watch as you add and fill in the missing data.
I'm finding that screen share works actually better than in person for equitable distribution, because they can actually see the numbers change, and you can email them the spreadsheet in advance. So they can also look at the formulas behind this. So it takes a while to get comfortable with screen share, but once you do, it actually works even better than in person. So I would really be using that just to even show the inventory, and the clients like it.
Just be very careful to share the right screen.
So that's one of the things you want to make sure that you have those up in advance so that you have access to them, because if you're fumbling through your directory, they may see something they shouldn't be seeing about another client.
Right.
But good job. I think that the other thing I wanted to ask is, there is a difference between legal information and legal advice. And Gary, I mean, explaining what equitable distribution is not legal advice, that's information. Why are you concerned about even giving them information?
I'm not. I mean, I would explain to them at the first session probably, if you were to go to trial, which lawyers use as a barometer for giving advice to clients, what most likely would be the range or the parameters if we went to trial in terms of support, equitable distribution. I would explain how a judge would do it and not tell them what the likely outcome would be, but I would say, this is what equitable distribution involves. This is what alimony involves. This is the formula for alimony: marital lifestyle needs minus net earning ability to see whether there's a deficit. If so, how much? Then do the same for the other spouse. So I would explain all that, Anju.
Okay, so one more question, if Carl will indulge me. What if one or both of your clients have been pro se? How would you have approached this differently? Many of my clients are pro se, and I have my own view, but I'm interested in yours.
Cindy?
I don't give legal advice either. Carl, I'm really intrigued by the memo, and if you could email it to me too, I'd appreciate it. I think legal education is very different than legal advice. So I, as Carl has said, I educate very clearly on what a court can do, what's been my experience, what the law says, all of those things with a pro se. But I will say to them, I had one recently where one of the parties wanted to argue about an emancipation factor and whether if a child ran off and got married, whether they would be allowed to come back and start child support again. And it was more of a philosophical battle, but I knew that there could be legal ramifications to it. And I was trying to educate the party on, well, what could potentially happen. And he kept saying to me, well, should I do it or shouldn't I? Should I agree to that or not? That's legal advice I can't give. I can just educate you. I can give you all the, the parade of horribles that could come from it and the pros and the cons, but you making the decision would be me giving you legal advice, and I'm not going to do that. So I just try to give all the information possible so that they can make an educated decision, but then it's on them.
Well,
Jeff, what do you do,
really
Jeff, as a non-lawyer?
One's legal advice and one's making a decision for them or telling what they ought to do. But sorry, let me ask you one more question, Gary,
Yes.
which is that when the issue of Jeff's pension came up, it seemed like you discouraged getting that valued.
Really?
I mean,
I felt the same way, but I didn't want to pursue it. And
yeah. So
that's interesting. Yeah, I didn't intend to, but I do appreciate the feedback. I was attempting to explain that there are two options in how to deal with it, but thank you for pointing that out.
Okay. Normally you would encourage someone to get a pension value.
Well, I would tell them that it's one option they have. Some people are very penny foolish, dollar foolish, and they'll say, well, I don't want to spend $400 or $500 to do that. And if they both agree to divide it in the future when it goes into pay status, they don't have to get it valued. I don't insist on it, Carl, or urge them in every case. I explain the options to them.
Okay, well,
but you still have to do it through a quadro, and that's almost going to require evaluation because the drafter no,
it doesn't. The long as the quadro establishes the formula of how the ultimate monthly check is going to be divided on some percentage basis that can't be determined until the person retires. The numerator being the number of years of the marriage, the denominator being the total number of years in the pension plan. That's all you need. You don't need evaluation. That's interesting, Carl.
Wouldn't that change the situation that Jeff was posing? Was he was, I think, a state employee, so you can only divide it when it goes into payout status. If it were not that, it were a private pension where you can actually divide it and treat it separately, would your opinion be different or your advice be different?
When you say a private pension, you mean
like, a defined pension plan from IBM?
Yes. Well, that's really no different than the state.
Well,
If you-
it is in the sense that I think the state, you can only do it once it's in payout status.
That's right.
Whereas with IBM, you could actually separate it into two pieces.
Uh, only if it's a defined contribution plan, a 401k. If it's a defined benefit plan, I don't think they're going to apply anything until it goes into pay status. I mean, maybe we have different experiences there.
Well, Jeff, you know better than I.
Well, I think once it goes into pay status, if you're talking about something 20 years down the line, it seems to me that my preference is to have it valued, because the monthly payout now is not going to be the same monthly payout in the future. And then you've got to get into coverture factors and fractions rather, and all these other things. I just think it's easier to get it valued and then work with what you have.
But going back to the other question,
Yeah.
it was my understanding with a private defined benefit pension plan, if the pension plan permits it, you can divide that into two pieces before payout status. So one piece belongs to one spouse, one piece belongs to the other spouse, and they can do different things with it. Is that am I just?
It's, at the end of the day, you can't impose on a plan administrator anything that's outside of the existing plan rules. So to use your example, if such a thing is permitted in this IBM plan, then you can write your quadro that way. If it's like, for many plans don't allow for lump sum distributions. So you can't impose a lump sum distribution on a plan.
I know. Yeah.
I know, but I'm just.
But if the plan permits it, then it could happen.
Of course, yeah.
Which Carl, is a very important point. Whether it's litigation or mediation, you need to get a copy of the summary plan description.
Yeah.
Or look at the statute if it's a public sector pension, because then you'll find out what can or can't be done.
Exactly.
Okay. Well, we have reached our time limit. I want to thank all of you. It was really very good, great performance, great job. And so thank you very much. And thanks everyone for attending. Let's see, what is next week? Next week is, we're going to have a CLE webinar, and I think the topic is negotiating from a position of strength, or something like that.
Yes, that's it.
That's it, and it's Felicia and Lawrence Eichen are going to be the presenters. So I hope to see you then. Everyone have a great week.
Thanks, everyone.
Thanks.
Okay.
Bye-bye.